Buenas tardes a todos.
A very good afternoon to you all. We'll just give you a couple of seconds so that those of you that need them can put their headphones on. The third pillar of the guiding principles is on access to remedies for actions committed by both states and companies. We have to think about treaties at regional and international level and the jurisprudence from United Nations bodies when it comes to victims' access to remedy. The guiding principles recognize this right. Now, one of the aims of this third pillar is to make sure that victims have more channels available to access remedies and that they can tackle some of the problems caused by corporate activities. So this covers a broad range of mechanisms under Pillar 3. Some people say that one of the reasons why the guidelines don't say very much about non-judicial remedy is because they want to introduce a sort of light version of responsibility or of justice. But that's not the case at all. There are three main reasons why complaints, non-judicial complaints mechanisms can be useful. First of all, they can be quicker and less costly than court proceedings. They can produce tangible solutions in a matter of weeks or months rather than having to wait for years through the traditional courts. Secondly, in some cases, they can lead to reconciliation or contribute to that, and they can create more harmonious social relations. Thirdly, well, if we have to think back to our previous mandate and to the information that we've collected in the working group, these complaints mechanisms make a significant contribution to creating a change and to creating a change within corporate culture. I think that the guiding principles are quite strong. We have to think about the conceptual note for both the judicial and the non-judicial remedies, and we have to think about the relationship between what companies do and the impact of their actions. The guidelines establish that the companies that have caused or that have contributed to a negative impact must provide remedy or contribute, cooperate in the provision of remedy. If it's the company only that has to do this, then there is no hope for remedy, but only for action. I think leverage is the word that we use in English, and it's not something that can easily be translated in Spanish, but it's basically about using your influence to try and effect a change. So we very much hope that this leverage can be used to try and mitigate the negative impact. These standards of conduct can certainly help both the judicial and the non-judicial grievance mechanisms, and that they can be effective to solve problems and provide reparation for victims. Now, this panel is specifically going to focus on non-judicial remedy. I wanted to extend a cordial welcome to the panelists and invite them to give us examples of their experience and their point of view, and we'd like them to tell us basically three things. What are the factors contributing to ensure that non-judicial mechanisms work as expected within the guiding principles? In other words, how do you ensure that they follow the 8 criteria for effectiveness? We don't simply want to repeat the fact that the 8 criteria are necessary. We know that already. It's already in the guiding principles. We'd like to know more about how we can make sure that they can become operational in practice. And perhaps the second group of issues to be tackled is that what can we offer to those affected, in other words, the victims, and those who work with non-judicial grievance mechanisms in companies and in state bodies or in multi-stakeholder agencies? What can we tell them about the different kinds of remedies that are most widely accepted between the parties, the kind of remedies that truly aim to solve the underlying problems, the kind of remedy that are most in line with human rights concepts? So to be absolutely clear, I'm really talking about outcomes here. The working group wants to examine the usefulness of producing guidelines in this area. And thirdly, I'd like panelists to think about how the different non-judicial and judicial mechanisms can work hand in hand and can dovetail with each other. So once again, welcome to all of you. I would like us now to get started with Loretta Rosales from the Philippines.
Thank you very much. Muchísimas gracias. Okay. My talk is entitled The Watershed Approach to Stakeholder Grievance Mechanism in the Context of Mining in the Philippines and the Right to Environment. Yolanda or Haiyan is the new normal, and it can happen again anywhere in the world, whether we like it or not. It struck the Visayas, the central part of the Philippines, with a force and magnitude way off the chart in recorded history, and left our countrymen living in that region in utter devastation in just a matter of hours. With a staggering loss of lives and properties, leaving behind the destruction has become the only option for many survivors on account of bleak prospect of recovery. Thus, the people, mostly farmers and fisherfolk, among the most vulnerable sectors, are now internally displaced. At the moment, our government is now in the thick of doing relief operations and at the same time at the threshold of planning the gargantuan task of rehabilitating and rebuilding the lives of thousands of Filipinos in the central part of the Philippines, with the help of countries, international organizations, and of course our Filipino brothers and sisters within and outside the country. The guiding principles under the pillar of corporate responsibility to respect highlight the context under which a corporation will operate and impose the responsibilities that it should observe. On this note, I wish to build my perspective on the non-judicial remedies in relation to how mining is done in the Philippines and the right to environment in relation to human rights norms on the right to life, right to water, right to information, among others. This recent extreme weather event now raises questions on the feasibility of tapping the economic potentials of mining as one of our development goals, obligation of the government to protect, and the responsibility of mining corporations should consider the increased environmental risks in the context of climate change and extreme weather events and the archipelagic nature of our country in relation to providing remedies, whether judicial or non-judicial. The right to environment, along with the recognized human rights norms of rights to life, information, due process, among others, are constitutionally guaranteed by the Philippine Constitution. We have an environmental rules of procedure that provide, among others, the procedural right to question any development project that will affect two or more cities or provinces through the writ of kalikasan. The national legal framework on mining provides that the state is the owner of all natural resources, which include mineral resources, and it is authorized to enter into agreements for the utilization, exploration, and development of such resources. Theoretically, the Philippine government should be able to negotiate a mining contract through the Financial Technical Assistance Agreement with mining companies in mutually beneficial terms. But given its lack of resources, capacity, and weak governance, the government oftentimes appears to default in the mining corporation, in the actual implementation of the contract, and this includes the availability of grievance mechanism for the stakeholders. A case in point is the Tampakan Copper Gold Mining Project of Sagittarius Mines Incorporated. SMI, which was recently acquired by Glencore, based in Switzerland, one of the top 10 mining companies in the world. Very recently, it has scaled down its operations, but it plans to undertake the next phase of mine production in 2019 in the face of a provincial environment code banning the use of open-pit mining. The potential damage impacts not only on the mining-affected communities, but on our country as a whole. The final mining area, FMA, covers approximately 9,605 hectares of land located between the quadrant boundaries of 4 provinces, which straddle 4 ancestral lands with certificates of ancestral domain title. CADT of the Blaan indigenous peoples. It lies in an area with 14 fault lines. A study noted that in terms of the biophysical environment, the project will directly impact on waterways and watersheds and will have cumulative effects on biophysical elements of whole ecosystems from ridge to river to reef. The grievance mechanism as a mode of non-judicial remedy will not be able to conform to the effectiveness criteria of the guide principles if it will not involve the stakeholders within the watershed continuum. GP 18 provides that conduct of the human rights impact assessment should, and may I quote, involve meaningful consultations with potentially affected groups and other relevant stakeholders as appropriate to the size of the business enterprise and the nature and context of the operation, unquote. SMI's environmental impact assessment and the correlative duty to explain this to the affected communities failed in many respects. It lacks indigenous peoples' analysis and has no human rights study, including its implications on land rights of the IPs. Moreover, it can never be an effective planning tool for the affected communities and the local government units because it is a voluminous study written in English and in a very technical manner. More importantly, the appropriate stakeholders were not even consulted. The inherent weaknesses in information generation and dissemination have exacerbated the conflict situation in Tampakan. In October 2012, a mother and her 2 sons from the Blaan IP community were killed in a military operation. According to the military, the fatalities were an unfortunate result of an armed encounter in an attempt to pursue Dagil Capion, a tribal leader and father of the victims, who has an outstanding warrant as a suspect in the killing of a personnel of the mayor of Tampakan, who happens to be also a contractor of SMI. Last June 2013, a Blaan leader, Eking Freay, and his brother-in-law, Sunny Boy Planda, were ambushed allegedly by members of KAFGU under the Task Force Kitako. In the aftermath of the incidents of these killings, the Philippine Commission assumed the role of a mediator with the help of a Catholic bishop of a local diocese. On 2 occasions, the Commission facilitated dialogues among the stakeholders, which included the military, tribal leaders of Blaan communities, and the IP residents from the affected communities who are for and against the mining project, support groups from local and national civil society groups, and the local officials from the 3 municipalities covered by the mining project. These multi-stakeholder dialogues served as a venue to discuss immediate and strategic concerns. For instance, it served to clarify certain factual issues related to the violent incidents complained of by the families of the victims, and also tackle the various grievances against SMI and the military. To provide assistance to the families of the victims, the Commission also conducted further investigations on the killings, including the conduct of medical legal examination on the victims and the provision of security for a child witness. Dialogue-based mechanism in this context is effective to a limited extent, and that is to diffuse the tension in the conflict area. It is helpful that the Commission has established coordination with other state agencies like the security sector, as this has contributed to build confidence in the process and enable the Commission to mediate between and among the stakeholders. In this specific instance, the heightened conflict could have been prevented had SMI assumed a proactive role to address valid grievances of the affected mining communities. The Human Rights Impact Assessment, HRIA, conducted on the Tampakan mining project is very instructive. Given the long time that SMI has been active in the area without a formal grievance mechanism and the level of frustration among interviewees about possibilities to seek response to queries and complaints from SMI, we conclude that at the time of writing, there is a dysfunction in the company's grievance system, and so on and so forth. I won't read because I just have one more minute. The non-judicial remedy is not a standalone mechanism, but should be a part of the continuum of remedies, from non-judicial to judicial, where appropriate, that should be provided to the victims both by the state and the corporation. In this case, the Philippine government and SMI respectively. These remedies should take into account the context under which the proposed business project is to operate. The mining project has been recently acquired by Glencore. Again, this is Swiss-based. Under the guiding principles, conduct of due diligence is necessary wherever changes in management in the business undertaking is effective. Thus, it is an opportune time both for the Philippine government and Glencore to review the conflict resolution mechanism related to the mining project and the looming environmental risk, both at the operational and community level, on the part of SMI and policy level through formal non-judicial mechanism. Although there are reforms in the mining policies through Executive Order number 79, business and human rights framework has yet to be introduced or mainstreamed. It is in this regard that the Commission as an NHRI finds greater challenge, as this will definitely influence the kind of remedies that will be available to victims of business-related human rights abuses in the context of environmental risk of the project and its impact on universally recognized rights to life and development, among others. Thank you very much.
Thank you very much, Madam Chair. I would like to give the audience a little bit more of an introduction to myself, because when I'm not at the Danish National Contact Point, I'm a university scholar of human rights and business, and invariably this influences the way that I go about being in the National Contact Point. My background is in international human rights law, and also I've been doing some work on alternative dispute resolution. And invariably this just influences, as I already mentioned, the way in which I also perceive national contact points. I would like to start out by mentioning a point made by a Norwegian criminologist back in the 1970s, where he said that one of the beauties of mediation as a conflict resolution mechanism is that this is a process that's different from the legal process, which very often turns lawyers into the professional thieves in the way that they steal the conflict from the affected parties. And so when we talk about national contact points as mediation organs or institutions, the beauty, at least the beauty in theory, is that this process may have the opportunity to repair relationship between the affected party and another party. So that, for example, if there's an employment relationship, this may go on. I'd like to say a little bit more about that later on. But what this means, of course, is that if NCPs are to be trusted and provide effective remedy, then they must also function efficiently and legitimately. I'm aware that some hesitation surrounds non-judicial state remedies, and I'm sure that we are going to be talking about that later in this panel. As was also indicated in the previous session, there are a number of problems, sadly, affecting state-based judicial remedies, which often do not provide effective remedy. So what this means is, I would like to argue that one is not to exclude the other. The two can complement each other. Because if state-based judicial remedies do not deliver accountability, non-judicial remedies may at least complement the state-based remedies. A little bit about the Danish National Contact Point. It was reorganized in 2012 under the name of the Mediation and Complaints Handling Institution for Responsible Business Conduct. Not a bit of an awkward name. So it's not called an NCP, and if you Google it to find it, do not look too much for the Danish NCP, but it is an NCP. Just try to maybe remember this different title. What happened with the reorganization was that the Danish Parliament, the legislature, decided to give the Danish NCP a legal basis. So now it has a statutory legal basis. The Danish NCP was the first one to be given a legal basis in this way. It was also given a new organization. The previous one was launched under a governmental department and staffed by governmental civil servants with some other organizations, stakeholders participating. Now we have a different structure in which we have 5 members, which are the active members. We have a chairman, an expert member, and 3 representatives nominated by industry, labor, and civil society, respectively. And I'm the latter one. I'm the one nominated by civil society. We also have a secretariat with 4 or 5 staff. They're part-time, but this means effectively that they are available full-time when needed. We receive government funding, quite generous for a relatively small country. With an NCP, we receive around 400,000 euros per year. And so this is the perspective from which I speak as a member of the Danish National Contact Point. The idea to give the National Contact Point this legal basis went back to advice given by the Danish Council on Social Responsibility, which is an advisory council to the government. And one of the other things that was introduced with the change was that there are now time limits, quite strict time limits for handling of specific instances or grievances. And there is also the opportunity for the National Contact Point to take up a case on its own initiative. And finally, grievances may be lodged not just against businesses, but also against public organizations like Danish government institutions or regional institutions in Denmark. Now, when I was asked to make this presentation, I asked around in my among the groups that nominated me and also some of my colleagues to try to find out what sort of groups that were a little bit more removed from the national contact points actually thought was important for national contact points to deliver effective action on the ground. And there were 3 issues that struck out. One was organization, the other was resources, and the third one was knowledge. On organization, it was indicated, again with the reservation, that I spoke mainly to people sort of in my own network, and many of these, of course, are in Denmark or surrounding countries, but it was indicated that it's important that the government somehow indicates signals that the NCP is a priority. This can be through a statutory legal basis, but it can also be on other measures depending on the national culture. It's also important that the organization is such as for the national contact point to be trusted and seen as trustworthy. This means that the composition should be non-biased, both from the public and private interest, and also there should be knowledge about the richness and complexity of human rights in relation to business. There should be resources enough to make this a body that can actually handle complaints, can act effectively and efficiently, to have knowledgeable staff and as well as secretarial backing, and also for resources to ensure effective access for affected parties. This entails information and advice on what is actually required for lodging a grievance, such as in relation to documentation. It also entails economic assistance where needed for the affected parties, as well as knowledgeable assistance for and during the remedial process in terms of some sort of counsel. And then on the point of on knowledge, which is also in general my own pet issue on business and human rights, there is a need to explain the human rights implications of human rights to business to all stakeholders. Obviously to business, because without understanding this, again, this richness and complexity of human rights for business, how a business is going to respect human rights. I have an example I'd like to refer to at the end. To affected communities and individuals, because without the knowledge about, again, what type of action that they meet could entail a human rights violation, how would they be able to react? To civil society, because how else would they be able to monitor and assist affected parties in lodging grievances? And for states and NCPs, because without this knowledge, again, of translating human rights into business implications, how would they effectively be able to deal with grievances? Now, on this point, on the complexity and richness of human rights to business that I mentioned several times, I'd like to refer to an example that was given to me by Margaret Junk, now a member of the working group, when she was still at the Danish Institute for Human Rights. Many individuals will think about the right to freedom of movement as a human right to be violated by states. A lot of people would not think about this as something that businesses could in any way affect. But when companies do, as actually happens not so rarely, as many of you will be aware, when companies require employees to deposit their ID with the employer for any reasons, like in order to get a salary advance, in order to get the contract for any other purpose, this may entail a violation of the human right to freedom of movement. So human rights need to be translated and explained to businesses in order for effective action on the ground to occur. I know this has been said many times. I know that the Global Compact has been doing a lot of work on this previously, but I think with the guiding principles there is a momentum, but also acute need to revitalize this process in order for it not to go stale now that we have the endorsement of the guiding principles. And there is also a need related to this for national contact points to develop guidance on through developing due diligence practice in order for businesses to understand what they're expected to do to act on the ground in order to ensure respect for human rights, and so that they may also avoid cases in front of NCPs, which I believe many of them would prefer. Thank you very much.
Buenas tardes todos. Ahora.
A very good afternoon. I think you can all hear me now.
Last spring, when the Fair Food Program was honored by a visit from the working group, delegation members said that it would be important for us to come to this forum to share the measurable gains, empowerment, and access to remedies for historically marginalized workers that were being achieved by a multi-stakeholder, worker-driven program. So we are very happy to be here, and we hope to fulfill the request to be that hopeful voice this afternoon. I live and work in an area of the United States that federal prosecutors have called ground zero for modern-day slavery. Despite the dismal history behind that label, my presentation today could be titled From Ground Zero for Modern-Day Slavery to Zero Slavery Cases on Fair Food Program Farms. That transformation has taken place in a $650 million industry, impacting close to 100,000 workers each season, because of a very effective combination of rights and enforcement mechanisms established by the Fair Food Program. The program is a multi-stakeholder initiative of workers, buyers, and growers in Florida's tomato industry. As you will hear, it is worker-driven and built on a premise suggested by the guiding principles that purchasing power of major food buying corporations can and should be used to address the adverse human rights impacts its downward pressure has historically exerted on wages and working conditions. That pressure, coupled with farm workers' exclusion from most legal protections, consistent violation of their few existing rights, and notoriously weak, under-resourced state enforcement, had resulted in sweatshop conditions and self-poverty wages, with forced labor and sexual assault impacting thousands of workers at the worst end of a spectrum of systemic abuse. The program is the product of the Campaign for Fair Food, launched in 2001 by the Coalition of Immokalee Workers, an organization founded 20 years ago by farm workers from Mexico, Guatemala, and Haiti. Initially, coalition members referred to the Universal Declaration of Human Rights as a framework and support for their efforts. CIW gained international recognition for anti-trafficking work, but found that traditional means of prosecution, work stoppages, and strikes were of little avail in creating systemic change. Applying the guiding principles concept of remediation, however, workers and consumers of conscience have thus far convinced 11 major corporate buyers with identifiable brands, from McDonald's and Subway to Sodexo, to sign legally binding Fair Food Program agreements. Participating buyers pay a penny more a pound for their produce passed to workers in their paychecks, and they purchase their Florida tomatoes only from growers who implement a human rights-based fair food code of conduct. Dramatically, as a result of participating buyers' commitments, 90% of growers in the industry have joined the program. The code of conduct was drafted by workers, growers, and consumers, and a working group continues to elaborate its guidance manual. It includes zero-tolerance provisions for forced labor, violence, child labor, and sexual assault, and a series of important guarantees concerning working conditions, many of which are based on and compatible with internationally recognized human rights and go far beyond local law. Important and unique provisions were generated by worker insight into needed improvements in hiring practices and conditions. Its standards are not aspirational. Rather, prompt and severe market consequences for violations are mandated. Representative of a very strong commitment to making the program's guarantees real on the ground are the following code requirements. Worker-to-worker education sessions conducted by the coalition at all participating growers to inform farm workers of their rights, including information about the program's worker-triggered complaint mechanism and its monitoring through proactive audits. This investment of resources ensures that the mechanism's intended beneficiaries know about, trust, and are able to access them. Then, the creation of the Fair Food Standards Council, a separate monitoring and enforcement organization indigenous to this program and unique in U.S. agriculture. The FFSC conducts intensive audits at all participating growers in announced and unannounced visits. Large percentages of workers are interviewed in the fields and off-site. Audit reports and corrective action plans, which are detailed roadmaps to compliance with firm time frames, are provided to the growers. We also respond to a 24-hour complaint line. Our multilingual staff investigates and resolves those complaints, normally in collaboration with and through negotiation with participating growers. Dialogue is the norm. Formal decision rendering where consensus has not been reached, the exception. The complaint process is transparent. Impacted stakeholders are continuously informed and consulted. Investigation and resolutions are expedited, achieved within days or weeks to be meaningful given the seasonal nature of the work and worker turnover. Our resolutions and corrective actions frequently have an educational component for workers and supervisors, and they address systemic as well as individual issues. Statistical analysis in our recently published State of the Program report demonstrates an even-handed approach in resolving hundreds of complaints. The input of thousands of workers who access the complaint process, speak to auditors without fear of retaliation, participate in education sessions, and health and safety committees at every participating grower enables the Council to monitor the program with integrity. Most growers have come to recognize the eyes and ears of the Fair Food Program as beneficial risk management for their operations, prevention that is highly incentivized by potential loss of sales to participating buyers. I leave you with this thought. Access to prompt, effective remedies backed by market consequences have helped to achieve the previously unattainable standard, a gold standard, if you will, of prevention of human rights abuse, resulting in 0 forced labor cases at Fair Food program farms in 3 seasons. The industry's worst actors are being weeded out and systemic changes implemented as a new day truly dawns in the fields.
Thank you.
Gracias.
Thank you very much, Laura, for making that statement. Something that tells us that one can do things. I would now like to turn to our commentators for this panel. Now, my understanding is that you've decided to speak in a different order, and Dwight will take the floor first. So, Dwight, Justice.
Confederation.
You know, for a model operational level grievance mechanism, I think we should consider a department store returns department. Customers return the goods for exchange or refund, and the company decides. And if the customers don't like the decision, they may have other recourse, maybe with the manufacturer or a governmental agency, or maybe in court. The department store understands that that it needs to be prepared to pay remedy, that remedy will cost, and that if it isn't prepared to pay, the mechanism will not do what it's supposed to do. Now, there are lessons from this, and I think the first lesson is that it's not necessary to have an independent or impartial procedure. Now, the second lesson is that the enterprise must be prepared to pay for remedy. I would think the measurement of an operational grievance mechanism is whether it actually provides remedy, and the early and direct remedy that's set out in Principle 29. In short, most of the good outcomes, if we're talking about outcomes, will cost. Now, an essential feature of guiding principles is the distinction between the state duty and the business responsibility. Now, there are limits to what an operational grievance mechanism can do, and it certainly cannot replace the judicial role of the state. Even multi-stakeholder initiatives cannot do this. Operational level grievance mechanisms must not prevent rights holders from seeking remedy in other ways. The ability and the will to provide remedy must be present. Consider the complaints mechanisms developed in connection with the supply chain codes of conduct and codes of labor practice. Workers in the supply chain are provided with a means of reporting code violations to code organizations or to the brand name sourcing company. The sourcing company is then supposed to get its supplier to provide the remedy. Now, these kind of mechanisms may have a part in a larger due diligence process, but they cannot be fairly considered the operational level grievance mechanisms called for by the guiding principles and would not meet the effectiveness criteria set out in Principle 31. Probably the largest category of non-judicial grievance mechanisms and sources of remedy, certainly having the greatest impact and meeting the effectiveness criteria, involve trade unions and collective bargaining. The unequal power relationship between a worker without a trade union and an employer means that the enterprise-level grievance procedures where workers are not represented by a trade union are unlikely to be seen as credible, and the experience is they do not really work and they're little used. Moreover, there must be a basis to resolve a grievance. Law is the basis in a judicial resolution, but without a collective agreement, there may be no basis for a resolution of a labor grievance in a private way. The right of workers to join or form a trade union can be found in every instrument in the International Bill of Rights and implicit in the ILO Declaration on Fundamental Rights at Work, which explicitly recognizes the right to collective bargaining. Now, just to conclude, there is no human right to a non-judicial grievance mechanism, but there is a human right to join a union and to bargain collectively. And so when setting up non-judicial grievance mechanisms, you need to have due diligence that in the process you don't violate a human right.
Gracias, Dwight. Quisiera invitar.
Thank you, Dwight. I'd now like to turn to Joris.
Perdón. Joris Oldenziel de la ONG SOMO.
Joris works for SOMO, which is an NGO.
Chair. Indeed, I am working for SOMO, the Center for Research on Multinational Corporations, which is also the host of the OECD Watch Secretariat. And as OECD Watch, we support NGOs in filing cases under the OECD guidelines, which is one of the well-known state-based non-judicial grievance mechanisms. And as SOMO, we have a 4-year program funded by the Dutch Foreign Ministry on non-judicial grievance mechanisms. So we do a lot of analysis and support for local NGOs and local communities on using different grievance mechanisms and getting access to remedy through these mechanisms. I thought the different presentations were very interesting, and I think it's very important to take into consideration that there are so many different types of grievance mechanisms. And we've seen 3 very different ones here, and I think we have to discuss them separately because there's different issues in relation to all of them. Maybe to start with the operational level grievance mechanisms. We all know that there's these effectiveness criteria, but the problem at the moment is that nobody is actually checking or monitoring whether the operational level grievance mechanisms of companies are indeed in line with those criteria. We at SOMO, we did a research over the last couple of years where we interviewed 270 workers from 16 electronics companies from factories in China, India, Mexico and Thailand. And we questioned those workers regarding the grievance mechanisms of those companies. And one of the key things was that there is a lack of trust in those mechanisms, and that's mostly because of the lack of independence of those mechanisms. And we looked at, for example, accessibility, predictability, and transparency, and they scored high on one account, which is the predictability, because if you file a complaint, you can rest assured that nothing will be done with that complaint. And it was sometimes very shocking, to be honest, to see how badly these kind of mechanisms are implemented. To give you an example, if there's hotlines where workers can call, but often the telephone is hanging next to the manager's office. So there's a lot of lack of trust that there's no retaliation if you use it. We often saw that when you call that hotline, the person answering the phone doesn't realize he's the grievance mechanism. So, I mean, even these very simple elements are still not being implemented. I do think that therefore there has to be a very clear recognition that there's limitations to operational level grievance mechanisms, even though that there may also be benefits to them to avoid escalation and address serious concerns. But I think, Dwight, you made a very important point that they should not undermine collective bargaining. They should not undermine human rights, for example, through legal waivers, which we have seen. And they should not preclude access to judicial mechanisms. I thought that the presentation of the Danish NCP was very interesting, and we as OECD Watch, we recognize many of the points that you have been mentioning as important elements of success. The organization, the resources, and the knowledge. And we, for example, with regards to knowledge, one of the key problems with many of the national contact points is that they are based with ministries that are tasked with promoting the business interests. So the Ministry of Economic Affairs or Ministry of Finance, and these are not human rights experts. So the NCPs that are dealing with these complaints are experts in the field of investment policy or investment treaties, but not in the field of human rights. So that is a very important barrier to effective functioning of the national contact points. Another point that I thought was very interesting was the issue of the need to further train companies and build the knowledge of companies with regards to what are their human rights obligations, and not only the human rights standards as such, but also the scope of the responsibilities that they have. We recently filed a case against pension funds for their minority shares in a Korean company. And it was interesting to see that some of those pension funds didn't really realize that under the UN guiding principles, they have a responsibility to respect, even if they have a very small percentage of shares in a certain company. So the due diligence requirements under the UN guiding principles and under the OECD guidelines go further than just causing and contributing, but also being directly linked through your products and services by a business relationship. So that kind of knowledge has to be built through NCPs and other competent bodies. And I think I have to leave it with that. Thanks.
Joris,
Thank you very much, Joris. I think you've given us some excellent information. I wanted to emphasize this very point which Joris raised at the very end in relation to this panel. If we think about Pillar 3 and think about non-judicial and judicial grievance mechanisms, well, we often forget that the whole range of non-judicial grievance mechanisms is actually quite broad. And quite often we confuse things in our discussions. We have the example of an ombudsman that carries out investigations and can promote a dialogue through a national contact point. You, in fact, carry out initiatives on your own initiatives. You don't necessarily wait for complaints to come in. So there's a structured agreement with rules that are in place. And Dwight, when he spoke, reminded us that there's a whole series of rules and regulations in the labor sector that have been put in place through legislation. And that certainly affects complaints at the workplace. So everything that has been said reminds us that it's a very broad spectrum. And here in the panel, we have heard about the administrative measures that states have or that they can take vis-à-vis companies. For example, fines. And this has come out very strongly in all of the documentation that civil society has brought to our attention. Sometimes fines don't really solve the problem at all. They don't actually urge companies to change their conduct. They don't, in fact, particularly compel them to clean up their act. They simply have to pay. So I just wanted to draw your attention to this great variety of non-judicial mechanisms that have been mentioned here. Now, I'm not entirely sure as to whether I've had an answer to my question about outcomes and about the need to have outcomes. But that's perhaps something that we can touch on in our general debate now. So I wanted to turn to the public and ask them for their questions. Now, on my left, we have representatives of states. In front of me, companies, and to my right, civil society and other organizations. So if you would like to ask a question, please send that request in to the panel.
Voy a empezar entonces.
I'll start with a question from civil society. Danielle first.
Hola, ¿me escuchan?
I hope I can be heard. A good afternoon. It's a very great pleasure to be here. Danielle Tajan. I'm from the Human Rights Center for the Environment in Argentina. This is a very interesting panel. Our organization has filed 15 complaints of different kinds, 5 through the NCPs. 1 has been submitted to the Canadian Mining Council. 3 were for the violation of a particular principle. 3 were submitted to Nordic governments, violations committed by a bank. A further 1 to the World Bank, and I could tell you about 3 or 4 more, but I think I'll leave it at that. There's a common denominator to all of these, At the beginning, we really started on a very confrontational footing with the companies. And then after that, we tried other strategies to try and find a space for dialogue and a constructive approach to finding solutions. And I have to say that the recent complaints have been very constructive. But there is a basic problem. There is a real lack of will on the part of the company to truly undergo a conflict resolution proceedings. And there's also a lack of commitment on the part of the state to truly take these fora seriously. In some cases, the reaction of the national contact point, and I have to say that we really have tried to work with them, has been a pathetic reaction, to the point that some of them have picked up the phone and then claimed that they knew nothing about the case or didn't want to know anything about it. So I don't think we can trust in these fora unless there's a commitment on the part of the state, a commitment on the part of the corporate sector, and ultimately there has to be a cost for those companies that don't want to take part and don't want to abide by the resolutions.
Yes.
Thank you, Danielle. I now wish to call for a statement from the Ombudsman.
Gracias, President.
Thank you very much, Madam Chair. On behalf of the Ombudsman of the Bolivarian Republic of Venezuela, I wish to thank the panelists for the statements they've made. I wanted to say that the national human rights institutions have a very important role. They must develop these non-judicial grievance mechanisms acting in respect of violations committed by companies. And this is entirely in line both with the guiding principles and with the Human Rights Council resolutions. Now, these guiding principles are a huge step forward when it comes to the protection of human rights. We must recognize that. However, in the Americans, very often, the lack of a legally binding instrument on corporate responsibility for human rights violations makes it very difficult for non-judicial remedy mechanisms to help national human rights institutions. In our continent, companies don't feel legally bound to the guiding principles, and they therefore undermine these non-judicial mechanisms for remedy. There's been an example that's been submitted to our ombudsman. A construction company used all technical means at their disposal to derail a mediation process that had been undertaken by the Ombudsman. So we actually had to resort to the courts to try and find a solution. And I could tell you about another case about a cross-border insurance company. Thinking about all of this, it's important to bear in mind what many people have said, that we need binding international standards to hold companies to account for human rights violations. Thank you very much. I'd now like to hear from states, please.
Thank you very much. This is a short comment from the United Kingdom. And as with the previous session on judicial remedies, first of all, to welcome this discussion and the important work of the UN Working Group in this area. The UK government believes in the importance of remedy and the spectrum of remedy mechanisms, both judicial and non-judicial. And I think that this debate here highlights, as you've said, Madam Chair, the spectrum of remedies available and kind of the richness and diversity that we need to reflect on and expand on and improve on. And I wanted to highlight that in a UK context, we believe that we've got that spectrum domestically and best practice that we are keen to share with other states and in other contexts and learn from other states, ranging from company best practice on internal grievance procedure through to arbitration, adjudication, mediation, conciliation mechanisms available in a UK context. So I just wanted to highlight also that we stand ready to work with other states in this area, business and civil society, and we will support that through our action plan and our financial support. Many thanks.
Gracias.
Thank you very much. I see nobody from the business sector, so I'd now like to move on to civil society.
Sí, no sé en qué orden llega.
I'm afraid I don't know in what order you submitted your request to speak. Is it Catherine first?
Okay, so as some of you here will be aware, a Canadian mining company has now processed some 75% of some 170 Indigenous women who were raped and gang raped by its security guards through a non-judicial grievance mechanism at the project level. The company was made aware well in advance of a year of numerous flaws with this mechanism, including, but not exclusively, the fact that the women themselves were not consulted on the remedy to be given, that the remedy itself was not rights compatible, nor what the women themselves said they needed or expected. Additionally, the company made the provision of individual remedy contingent on the women signing legal waivers, granting the company legal immunity on the issues covered by the remedy mechanism. This company made a non-judicial grievance mechanism into a transaction of value, trading flawed remedy for legal immunity. Perhaps the panel can respond to this unanticipated use of a non-judicial grievance mechanism.
Gracias, Catherine, por tu inter.
Thank you very much for that statement, Catherine. Nobody's requesting for the floor on this side, so I'd like to continue with speakers from civil society. The representative from Indigenous communities who was asking for the floor earlier.
Es el representante de las comunidades indígenas, por favor.
Yes, the representative from Indigenous communities, please. Thank you very much, Madam Chair. I come from Guatemala. Pablo Seto is my name. I come from the Mayagil region of the country. It is indeed a very important discussion, and I welcome the experience and the goodwill offered by the United Kingdom. Thinking about how to help the corporate sector better understand the issue of human rights and to marry this with higher earnings and creating a better society. I'd have a question for the representative from the Philippines to try and understand whether in that country there is a recognition for the ancestral rights of indigenous peoples. Is legislation in place to this end, and is it enough to protect the rights of indigenous peoples? In my country, this has proved very difficult indeed. We haven't been able to do this. We haven't been able to provide any guarantees, either through judicial or non-judicial means. The Shil people 2 years ago opened a dialogue with the Green Power Company from Italy. The company recognized the rights of the indigenous peoples on natural rights along the lines of ILO Convention 169. It also recognized the ancestral authorities, but they were simply buying time and completing the construction of their facilities. They then dropped the issue like a stone and proceeded to discredit the indigenous authorities. I am mentioning this to try and see whether the European states could perhaps discuss these things with each other and try and make sure that the Italian example is better known. I'm also wondering what other mechanisms the working group can put in place on human rights. We do need to hear from the next speaker, so please conclude. Yes, I was really trying to urge the most vulnerable and the mechanisms to receive assistance and trying to find out what other help could be available from here.
Veo alguien en el puesto.
I can see a speaker from the States section.
I'm speaking on behalf of the government of the Netherlands. I would like to inform that during the consultations that we've done for our national action plan, which we hope to present before the end of this year, it became very clear for us that the stakeholders informed us that the state really has an important role regarding access to remedy, not only in creating and bringing under the attention the possibilities for remedy, for example, the national contact points and the important role they have to play, but also regarding capacity building for legal and non-legal remedy possibilities. The Advocate General who spoke earlier already mentioned it. We try to really work on capacity building. One of the ways we do that is through our Human Rights Fund. We are funding a couple of projects, like, for example, Access Facility, that is really playing an important role regarding non-judicial remedy mechanisms, but also a project on grievance mechanism that we do together with SOMO and regarding national contact points. So I would really like to stress that also in our National Action Plan there will be really a focus on the third pillar, and we think that it is really necessary to focus on what is possible in that respect.
Gracias a la representante.
Thank you very much to the representative from the Netherlands. I now recognize the representative from business. Good afternoon. Arantxa Arnaez is my name. I work for Repsol, an oil and gas company. I wanted to share with all of you what Repsol and what the PIECA Sectoral Association is doing about the operational grievance mechanisms. Repsol does have operational grievance mechanisms in place, is currently revising them to make sure that they are more effective and pursuant to the guiding principles. So PIECA, which is the umbrella organization for the oil and gas sector, started doing this work 2 years ago, and particularly looked at the guiding principle. In 2012, a handbook of good practice was compiled, and we're currently completing a series of pilot projects in the various companies that are part of IPIECA, precisely to see how in practice the mechanisms can be made more effective. We're doing this work in conjunction with consultants, and the outcome will be specific tools, a handbook which will be published in 2014. We very much hope that through the company operational grievance mechanisms, we will be able to have an early identification and settlement of grievances to try and make sure they don't escalate and actually become violations of rights. Thank you.
Última pregunta del lado.
A final statement from civil society. The gentleman back there.
Hi, my name is Joe Westby. I'm from Amnesty International. I would like to raise the particular need that non-judicial mechanisms properly take into account the different gender impacts of corporate abuses, and this follows on quite well from the shocking case that was mentioned on Papua New Guinea, and to ensure that women have access to these processes. To use an example from our own work, women in the Niger Delta area of Nigeria take a prominent role in economic activities and are particularly affected by serious oil pollution in the region. However, they are frequently excluded from post-oil spill processes. The oil companies deal with village elites and chiefs who are almost invariably male. Compensation is usually paid to leaders, and landowners, again, almost always male, men. So it's just to point out that when companies and states rely on such non-judicial mechanisms, they need to be careful not to reinforce gender discrimination.
Gracias por recordar.
Thank you very much for reminding us of that point during this panel discussion. Let me now turn back to our panelists. Perhaps they can react to some of the issues that have been mentioned by the various speakers. One of the issues that has come up is that we have a theory of the guiding principles, but we also need to think about effective implementation and practice, and there's no evaluation as to their quality. So there must perhaps be a mechanism for evaluating the quality of these operational grievance mechanisms. On the one hand, we can see that they're useful in avoiding the escalation of conflict and in making sure that problems are detected early enough. And perhaps that's more necessary in some industries than others because of the nature of their activities. but we've certainly been receiving information as to their usefulness. In any case, we have here a very broad range of experience on the panel. And without further ado, I'll turn to the panelists themselves. Perhaps we can start on my left.
I think that one of the points that has frequently been mentioned, and I have mentioned it myself this morning, is the problem of the fact that the UN guiding principles are not legally binding. Now, this has been mentioned over and over again this morning and then also this afternoon. So we had some discussion on this over lunchtime, and really, if you look at the guiding principles, they actually are drawn from treaties, no? The laws to which the state parties are signatories and, in fact, members of. So therefore, it is incumbent and it is a legal obligation of the states, of the governments, to comply with the principles of that are provided for in the guiding principles based on the provisions of the particular covenants to which they are members. The problem is with the businesses. The businesses don't consider themselves obliged to comply with this because they're not members and, you know, they're not the duty bearers that state parties are. So I think that's where the problem is. And so what has been mentioned is that the businesses, as pointed out by Professor Stiglitz this morning, Joseph Stiglitz, that it is important for the businesses to understand that human rights is good business because it involves the healthy relationship between the employers and the employees in a particular case, and then the company itself and the constituents to which it delivers the services. I think that profits, good profits, and good business can come in when you can gain the trust of your employees from within and also from the constituents to which you are serving. This kind of attitude can be developed, and I think that the UN guiding principles can in fact serve as a good basis for starting this kind of a relationship.
Loretta,
Loretta, I wanted to ask you a question, you and all the other panelists. There are different possibilities of domestic regulation which states can introduce to try and provide an incentive to corporations so that they can take part in these voluntary dispute settlement mechanisms. And then there's the market incentive that the Fair Food Council was talking about. But you're saying that you need regulation. What do you think about domestic regulation? What exactly is needed then?
Okay. I think that the state must first be made fully aware of its own regulation, of its own commitments, its own obligations, because it is the state that will, in fact, take the lead in developing the kind of national regulations that can get all stakeholders to comply with this, including the businesses. So there is a relationship, but I think that, you know, unless you are able to strengthen the state mechanism or the state commitment itself, businesses will always try to, you know, get away from this because they're interested in profit, they're interested in good business. So in this case, I think that the state, both states, state of the host country and the home country, can in fact develop that kind of a commitment, you know, so that the businesses themselves will be more inclined to comply with what both states are saying.
Okay, gracias.
Thank you very much. Let me turn to Karin Buhmann.
Thank you very much. I noted several very interesting points during the discussion, but I'm going to focus on those that I think are the most relevant from the NCPs. First, the point that was made on the strong need for commitment on the part of the state, which I believe could be extended also to a strong need for commitment on the part of businesses as well as civil society. It's in the interest of everyone to make remedies work, whether these are judicial or non-judicial, but now we are talking about the non-judicial ones. I believe, as was mentioned by the previous panelists, that it's really in the interest of business to respect human rights. It's also in the interest of civil society to make remedies, non-judicial remedies, work fast, or to make them work because this is an opportunity to solve conflicts fast and close to the spot where they occurred, rather than having to go to the courts of law. So really, I would like to stress this commitment and urge this commitment with everyone who's present here today. The other part is on the issue of collaboration between states that was also mentioned, also as regards to NCPs. It's obvious that if NCPs are to be trusted and to be seen as legitimate, it's very important that the less successful, or the records of the less successful NCPs does not overshadow that of those which are more successful. And there could be all sorts of factors why some are more successful than others, but it's a really good case for NCPs to debate between them and share experiences, but also for NCPs to share experiences with other non-judicial remedies, because all can gain from learning. The third point I noticed was on the mixed forms of regulation that also the previous panelists raised, and which was raised also by several of the people from the audience. And I believe this is one of the other points from the guiding principles that really deserves being more explored in depth. Leading me to the final point, and that is really the point on less is more, because we're getting into something that is becoming inherently more complex. And the more complex it becomes, the easier it is for everyone involved to say, this is just too complex, I'm just going to do the easy part. There was something called the Universal Declaration. Okay, let's go back there. And the danger of this is that's something I see already in the academic community, where I spent most of my time. There's so many people who know so little about human rights and who just encounter this issue on UN framework, UN guiding principle. What's it all about? Okay, there's something about guiding principles. There's something about UN Universal Declaration. Isn't that for states? Okay, what's the whole thing about? So the point is, somehow try to cultivate less is more in order to bring the message forward also. Thank you.
Gracias.
Thank you. Laura now.
In the spirit, oh, wait, I'm going to do it again. Yes? Okay. In the spirit of less is more, if you remember nothing about what I say this afternoon, then these 2 points, I will feel that we fulfilled the request of the working group. First, who is it that the remedies are intended to provide access to? And what would the structure look like if their voices were heard, if their voices were part of the design of the mechanism? Without that element, I think we will always fall short. It is very different if a program is designed to protect a corporate brand with the least investment possible than if workers are saying, what is it that they would like to see in such a program? And they would like to see, primarily when the rights are set forward, that they are enforced in a way that is significant, so that no one high up in the supply chain can say, as buyers in our area notoriously did, well, there may be slavery happening somewhere, but that's really not our responsibility. I work in an area where the Department of Labor has been abolished. It is called Department of Business and Professional Responsibility or some such thing. They are completely under-resourced. Unionism is a bad word in the South of the United States, and yet, with worker involvement, this structure has come up, and I know that Alexandra asked for results, and we don't have time to go into the detailed results, but I would urge those who are interested, this is a new report. I do have a few copies here, but I can tell you that $11 million have gone in those little pennies to provide economic security for workers over 2 seasons. Sexual predators are being weeded out. Workers are directly hired, put on growers' payroll for the first time, not subjected to wage theft. Those are very specific and concrete results that are being achieved, and over 300 complaints have been resolved in 2 seasons expeditiously and to the satisfaction of all parties concerned.
Laura, gracias.
Thank you very much, Laura. Dwight now, please.
Yes, I want to clarify that I was talking about operational level grievance mechanisms. There are other kinds, such as, for instance, the OECD guidelines and different levels. But to understand what I was saying, you need to think of operational level. Second thing, and I wanted to respond to something earlier, one of my main points is the right to join a trade union is a human right, and it exists even where the state fails in its duty to uphold that, never mind the business responsibility. And in every case, what I'm saying is that in order to avoid dealing with a union, sometimes companies will set up grievance mechanisms, but their purpose is, where their purpose in effect is to avoid dealing with a union, that might in fact be a human rights violation. Now, you have situations where companies use operational level grievance mechanisms in order to avoid making the proper remedy, and in order to, in effect, deny the human rights, which was the case that was raised earlier. That's a very similar concept to the one that I was concerned about, which is the misuse of an operational grievance mechanism. And finally, that gets to power. In the labor area, you need to have something like a trade union to balance the power with the company if the operational level grievance mechanism is to work. So basically, in the labor area, these mechanisms don't work without unions, and that's why industrial relations and collective bargaining is so important. There's a paper in the back that we wrote on due diligence and the right to join a union, and I hope you take it. It's very relevant to this discussion.
Gracias.
Thank you very much, Dwight. And thank you also for reminding us about how asymmetrical power is, and that's certainly one of the issues that we have to tackle in a very practical way when facing complaints. Joris now.
Very much. Just to respond to some of the comments from the floor. The representative of the UK was talking about the spectrum of remedies. And I think indeed there are many different types, as I said before, but I think we also need to consider very much what is still lacking. And the representative of SEDA was mentioning the importance of consequences. And here in one of the panelists from Fair Food Standards Council was also mentioning this as a very important driver for success. And I think we have to look at what are the consequences if companies are failing to cooperate with grievance mechanisms, or if one of those mechanisms determine that the company is violating the particular standards covered by the mechanism. Alexandra, you were saying what kind of domestic regulation could be employed to further support this. Well, I think on 2 levels. On the first level is on the level of the consequences. It can be very clear that if you are violating the OECD guidelines, you are excluded from export credits, you are excluded from joining trade missions, you are excluded from other government support. So everywhere where there's a state nexus, there is an opportunity for the state to ensure that there are consequences, even though that the mechanism is voluntary. And the other area is where states can look at how other mechanisms can be approved. If I look at Principle 27 of the guiding principles, it says gaps in the provision of remedy for business-related human rights abuses could be filled where appropriate, by expanding the mandates of existing non-judicial mechanisms or by adding new ones. And I think the Danish have done the first thing by expanding the mandate of the NCP. And I think there's also a good cause for developing new mechanisms, such as, for example, a commission that has a sanctioning and investigative powers, similar to, for example, a commission, a competition authority, or an ombudsman with those kind of sanctioning powers. Thanks.
Quisiera solo compartir con
I just wanted to share some information with you, something that hasn't yet come out from our discussion. We are familiar with the experience of the Ombudsman's office in Ghana, for example, where they do have a dispute settlement mechanism, but they have a whole series of rules and of levels governing the company's actions over a certain amount of time, and if that doesn't solve the problem, etc., then the Ombudsman can take up the case and prosecute it through the courts. So I wanted to let you know about this way of working things, and it hasn't been mentioned yet. It also hasn't been mentioned that at the business level, that there is a need to review quality. And some organizations have been working on indicators to try and assess the quality of all of these proceedings. And I think in some business sectors, there is recognition of the need to provide more information about the cases. Obviously, respecting confidentiality of victims or of sensitive information, but nonetheless providing information to explain to people exactly how they're unfolding. And finally, I wanted to thank everyone for the questions that they've put in respect of what else the working group can do to try and encourage this whole process of remedy. In its methods of work, the working group receives letters, individual letters, which we then forward to the countries. So using this system, we've sent out about 14 letters, and then obviously there's a whole exchange with the states and, if appropriate, with the businesses. It's all information which is publicly made available in the working group's reports. I just wanted to let you know about that. And then there's a very practical and real problem, and I'm not sure that we have an answer to this, but we certainly have to think about it, as Karin reminded us about. We need to know that there is a process, as Laura was telling us, there's a sort of process with rules, and when the parties come to an agreement, then the agreement is in place. And that is somehow the completion of a process. Well, the question that Karin was asking was whether, in respect of these agreements that are reached through non-judicial mechanisms, and there's a very broad spectrum of that, as we've heard, whether the parties can be legally bound to not reopen the case. And I think there's a need to be able to forecast, and I think we have to preempt this opportunism on the part of businesses. And then there is the needs of victims to be borne in mind. Obviously, no complaint mechanism can replace a criminal investigation and criminal proceedings when particular actions have taken place. There's no doubt about that. I just wanted to draw out this question that has been asked.
30 segundos, suficiente.
30 seconds will be enough.
Does it matter what language?
No.
Estamos hablando.
We're talking about a great number of mechanisms and organizations and structures. But the truth is that we're all human beings at the end of the day. We're all consumers. We all go out and buy products. We go shopping. We're parents. We go to church. And while we work away at all of these mechanisms and try and bring about this legislative change and change state conduct and put in place these out-of-court settlement proceedings, we can help to strengthen these mechanisms and make sure that we act as consumers and make sure that the market has a bearing on all of this. Thank you for that comment, Laura. I think on that resonant note, we've concluded the panel. I'm told that I only have 10 seconds left.
I just want to answer the Guatemalan question. He was asking if there was a law on indigenous people's rights. And in the Philippines, there is a law. It's called IPRA. This is Indigenous People's Rights Act. And it's a very good law. It's very comprehensive. But it is, of course, difficult to implement precisely because of the obstacles that obviously have been discussed earlier. However, there are some indigenous groups that have already been able to attain KADTI, the right to ancestral lands, precisely because of the effort, the process of dialogue, and the multi-stakeholders approach to this. Thank you.
Segundos finales.
Thank you.
Thank you very much. Thank you. I just wanted to make a point, or to clarify a point. In my initial presentation, I talked about the information efforts that have been undertaken by the Global Compact, and this doesn't mean that I don't recognize what has been done by the working group as well as the Office of the High Commission. I know you're working really hard on this also. Thank you.
Bueno, creo que hemos...
I think that brings our session to a close. As usual, at the forum, we've had a highly enriching day full of important statements. We've got a reception now for all participants. I think a round of applause for our panel.